I've asked the secretary to take a silent roll. Do we have any minutes to review? Go ahead.
Thank you, Mr. Chairman. I'd like to make a motion to approve January 29th, 2026.
We have a motion before the committee. All those in favor indicate by saying aye.
Aye.
Any opposed? Motion carries. Okay, committee, we will be meeting next Friday afternoon, not this Friday, the next Friday afternoon at 1:30, our regular time, so you can calendar and be prepared for that. Lots of work coming our way. Today, I think, is fairly light. We have 3 introduction hearings and 1 bill hearing. Each bill presenter can have up to 5 minutes to introduce their bill. Please start by stating your name and your legislative district. We will have some public hearing on the last bill, but no one's here signed up to testify. So let's get started. Representative Monks, RS 33126C1 is properly before the committee. Start when you are ready.
Thank you, Chairman. Committee, probably a little disappointed that there's not more to this legislation than there is there. I was working on some other legislation and came across this section of code as I read it, and I thought it was a little bit antiquated and thought maybe we should update that. If you'll notice that when we talk about justifiable homicide for a person, that it's when it's committed in the defense of a wife, husband, parent, child, master, mistress, or servant of such person, then you've got this reasonable argument. I thought maybe we should just get rid of all that and put another person. I think that was the intent of what we're looking to do, and that is it. Chairman, I'll answer any questions if you have any.
Committee, I can think of interesting questions. Representative Hill.
A motion, Mr. Chairman.
A motion is always in order.
Okay, I move to introduce RS 33126, Charlie 1.
Seeing no red lights, properly before the committee is RS 33126C1. All those in favor of introduction indicate by saying aye. Aye. Any opposed? Motion carries. Next up is RS 33111, Representative Schertz.
Thank you, Mr. Chairman. Good afternoon, committee. My name is Representative John Schertz. I represent District 9, which is the Western Treasure Valley, Payette, Washington, and Canyon counties. Before you today is a very short bill. Apparently, it's a lot easier to repeal laws and put them into place. This came out of our Title 18 review that I know a lot of you took part of during the summer, where we try to look at Title 18 and find things that were just no longer relevant, maybe were preempted by federal law or just hadn't been used at all or maybe ever. And I think we found, I have 3 of them here. This bill repeals Chapter 69, 76, and 77 of Title 18, which is Idaho Anti-Camcorder Piracy Act, the Tape Piracy Act, and the Motion Picture Fair Bidding Act. We could not find these had ever been prosecuted. They were largely, the federal government kind of has more of a role in doing these because a lot of this stuff honestly crosses state lines, even if it is done. And we've gone to such a digital platform where movies are released within a matter of weeks of being released in theater that a lot of these just are no longer relevant. So if someone does have a situation where they can find that these were prosecuted, please let me know. But we cannot find that. So I'm happy to stand for questions, Mr. Chairman, but would ask that the committee introduce this RS.
Representative Ehart.
Thank you, Mr. Chairman. Mr. Schertz, Representative Schertz, excuse me. Is this all we found?
Thank you, Mr. Chairman. Representative Ehart, I think we found some other ones. These are the ones that were assigned to me.
Representative Hostetler.
Thank you, Mr. Chairman. Just for a comment, I officially feel old.
Mr. Chairman, thank you, Representative Hostetler. I do too. Someone who remembers when this was actually a problem. So.
Representative Scott.
I will make a motion to introduce RS 33111.
See no red lights, properly before the committee is RS 33111 to introduce. All those in favor indicate by saying aye. Aye. Any opposed? Motion carries. Representative Scott, when you are ready, RS 33036.
Thank you, Mr. Chairman and committee members. Today before you is RS 33036, and this bill is about restoring some clarity in the separation of powers that are already established in Idaho law. Idaho Code 1213 has always stated that the court rules may not abridge, enlarge, or modify substantive rights, and that principle is not new. What this bill will do is there's no mechanism. If we find rules that maybe are in conflict with code, there's no mechanism. So what this resolution or this bill does is it will allow the legislature, if we believe that a rule is in conflict with statute or it alters substantive rights, or we formally notify the Supreme Court through a resolution. That's all it does. It's oversight but not control. It doesn't give us any authority to write court rules. It doesn't invalidate any court rules, and it doesn't interfere with the judicial independence. And if you look at the language, it's pretty simple. It just says the Idaho legislature may review any court rules, including but not limited to Idaho rules of family law procedure, Idaho court administrative rules, the Idaho juvenile rules. Upon any findings of conflict between court rules and Idaho code of rules abridging, enlarging, or modifying substantive rights, the legislature shall advise the Supreme Court of such conflict through a House or Senate resolution. So that's all this does, and I would ask that you would introduce RS 33036.
Representative Mathias,
Mr. Chairman, just for a quick question.
go ahead.
Representative Scott, as I read this, you mentioned this doesn't create any new authorities for us or anything, and so I'm asking, can't we already advise the Supreme Court through a resolution on their rules?
Thank you, Mr. Chairman and Representative Mathias. We could. It's not typical. It's not really ever been done. But through our family court task force, we realize that we need a process to make this easier, to bring things to the attention of the courts. And so we thought this would be a light touch on just bringing it to the attention, setting up the process, and drawing light to it that we can do that.
For motion, Mr. Chair,
Go ahead.
I move that we introduce RS 33036.
All right. Seeing no red lights, properly before the committee is RS 33036. A motion to introduce. All those in favor indicate by saying aye. Aye. Any opposed? All right. I'm going to hand the gavel to former Vice Chair Representative.
I just wanted to hit the hammer, but I guess I don't need to yet. Next up on the agenda is House Bill 525, Execution Procedures. Representative Skog.
Thank you, Madam Chair. Before you, Bruce Skog, District 10, Star, Middleton, Nampa areas. With me today is the Idaho Department of Corrections Director and also some staff, so if there are questions beyond what I have here, they're here to help us out. This proposed legislation extends the confidentiality protections currently afforded to persons or entities involved in the executions for the planning, the training, the performance by lethal injection or those in firing squads. As you remember, firing squad becomes the preferred method of execution now, and we're working on that facility to get that ready for those events. This bill has nothing to do with whether or not we like executions by firing squad or otherwise. It's just updating the code to be in alignment with the current court decisions or disputes that we have, also to protect members of the Department of Correction and those involved. This clarifies the execution protocols developed by the director, that they are not subject to judicial review, rulemaking, or other procedures under the Idaho Administrative Procedures Act. The condemned individual retains their right to appeals where appropriate under the Eighth Amendment or due process challenge or other ways. This is consistent with the recent Idaho District Court ruling dismissing a challenge to the Idaho Department of Corrections execution protocol by applying the definition of the word agency, which exempts the Board of Correction. This district court decision is currently on appeal. So I'm open to questions. I would ask that you send this to the floor with a due pass.
Thank you, Representative Skog. Representative Rubel.
Thank you, Madam Chair, Vice Chair, sitting, acting chair, for a question of Representative Scott.
Go ahead.
Thank you. So I noticed there's this catch-all of exemption from being subject to rulemaking, judicial review, or other provisions of Chapter 52, which I understand pertains to legislative oversight. So do I correctly understand that this change, if we made it to the law, would mean that there is effectively no legislative oversight or opportunity for discovery into procedures, et cetera, on behalf of the judiciary, the legislature, really any other branch?
Representative Skog.
Madam Chairman, I have a response, but I will defer to the Department of Correction if they are able.
Okay. Would you like to come up and state your name for the record and answer some questions?
Madam Chair, members of the committee, my name is Bree Derrick. I'm the director for the Idaho Department of Correction. And yes, it would be very helpful if you could just restate the question, please, Representative.
Go ahead.
Thank you. My question was, I'm looking at this line 27 of page 2 of the bill, that such procedures shall not be subject to rulemaking, judicial review, or other provisions of Chapter 52, Title 67 of Idaho Code. And I did a little bit of perusal of what's in Chapter 52, Title 67. It's very, very broad. And so I'm trying to understand if my assumption is correct that this would basically insulate the process from any discovery by, well, certainly by the judiciary branch, but also by the legislative branch, because legislative review is also, and legislative oversight is also laid out in Chapter 52 of Title 67.
Go ahead, Director.
Madam Chair and Representative Rubel, my understanding is that the historically, the procedures relating to execution have not been subject to any type of review. The Administrative Procedures Act has given the authority to the Board of Correction, and it's been interpreted to mean also the Director of the Department of Corrections to create rules related to execution that are not subject to review. And I think the reason for that is not wanting folks to weigh in, the public or others to weigh in on rulemaking related to execution procedures specifically.
Do you have a follow-up?
A follow-up question.
Go ahead.
Yes, so I'm wondering if that's already the law, then why is it in this bill?
Go ahead, Director.
Madam Chairman and Representative Rubel. So really the hope here is to make explicit what the court has interpreted as an implicit understanding of the legislature. So as Representative Skog was mentioning, this has been litigated actually twice. We're under the second court case right now. The first was dismissed because the interpretation from the Idaho Supreme Court was that the legislature had never intended for there to be, for the procedures to be subject to the Administrative Procedures Act. And so that court case against the Department of Correction was dismissed, and we are currently litigating a second case. So the interpretation of the court has been, please make it explicit instead of us interpreting it in court.
Do you have a follow-up?
I'm sorry.
All right, that's all right. Go ahead.
A follow-up to my follow-up. I guess my question is then, if it's insulated from any legislative oversight, any judicial review, essentially any discovery, how would there be any way to know if the procedures, if nobody can find out how the procedures are being conducted and it's totally insulated from any transparency whatsoever, how would anybody have any way to know if the procedures are in compliance with the Eighth Amendment?
Go ahead.
Madam Chair and Representative Rubel. So the procedures after they are created are all public. So our current execution procedures, our standard operating procedure is public. It's available on our website. And so they are available after the fact. This is just in the development of the procedures. So it's really relying on the department's expertise to develop procedures that are in alignment with the Eighth Amendment.
Does that answer your question, Representative Rubel?
I guess not exactly. I'm really sorry, but I feel like I should give someone else a chance.
That's what we're here for.
But I guess, when I look at the language of this, it seems like it would insulate any insight into it whatsoever before or after the fact. It simply says such procedures shall not be subject. It doesn't really clarify that whether that's beforehand, after the fact, at any point in the process. It seems at least the language of this, maybe practices might be different, but certainly the language of this bill would indicate that from soup to nuts, there is at no point any right for the public to know or for really anybody to know what these procedures are. Am I misunderstanding the language of this as opposed to, how you might go about it in practice?
Director, would you like to dig into that a little bit more?
As best I can.
The best you can, yes.
Madam Chair, Representative Rubel. So I am not an attorney or legislative drafter, so perhaps we might need a tweak on that, but the intention, as I understand it, and it has always been interpreted and practiced, is that this exemption is related to the development of the procedures, not that the procedures themselves are protected. And so, like I said, they are publicly available now.
Okay, I think that answered her question. Is there any other questions for the director or for the sponsor? Representative Mathias.
Thank you, Madam Chair. I just want to make sure I've distilled this line of inquiry down properly. So the procedures development is what this language applies to, not the procedures themselves?
Director?
Madam Chair and Representative Mathias, yes, that is the intention.
Okay, I don't see any other lights. Oh, I do. Representative Gannon.
Thank you, Madam Chair. So the procedures themselves, once they're in place, then they're made public, I assume?
Yeah.
Go ahead.
And follow up?
Go ahead, follow up.
And thank you, Madam Chair and Director. So, and then once they're made public, can they be challenged by anybody, or is there a process where they are challenged or evaluated?
Director?
Madam Chair and Representative Gannon, yes, I mean, they are challenged frequently. This is cause for litigation all the time for our department, so the procedures with which we carry out executions are frequently the cause of litigation.
Okay, I think that answered the questions. And any more questions for the director or the sponsor? If not, we're going to ask for testimony. So thank you for being with us today. I don't see anyone signed up. Is that? So is there anyone in the audience that would like to comment on this bill? Share your thoughts, ideas, get some public speaking experience? No. Okay. Representative Hill.
Madam Chair, I move to send House Bill 526 to the floor with a due pass recommendation.
Okay, we have a motion to send House Bill 525 to the floor with a due pass. So there's some discussion on that. Representative Rubel.
Thank you, Madam Chair, for a substitute motion.
Okay, we have a substitute motion.
If I might speak to that motion.
Go ahead.
My substitute motion is to hold the bill in committee. My reason for this is that ultimately it's the language of the bill itself that controls, not intent or what other extraneous practices might actually be, or even testimony in this committee. The language of this bill is very clear that such procedures shall not be subject, and not the development of such procedures, not any of that, not people's thoughts about it. It's the procedures shall not be subject to rulemaking, judicial review, or other provisions of the chapter. I guess my concern is this really, this is a case still going up to the Supreme Court, but I'm very concerned about the transparency surrounding this. I think when the state is taking the life of a person, that is a time for more transparency, not less. And there are very serious constitutional issues that, like it or not, we still have to comply with the Eighth Amendment. And I'm not saying anything about being against the death penalty. I'm just saying when we do it, we have to comply with certain constitutional strictures. And if we don't even know what the procedures are, and the whole process is insulated from any insight into it, which this bill would do, I don't think there's any way to even know if we would be in compliance with, who knows, with the Fifth Amendment, the Eighth Amendment, anything else. And so I think it is really, we have a heightened obligation, as I said, when the lives of people are on the line, when it is the state taking their life, I think we need to err on the side of transparency. And I can't think of any other thing the state does, frankly, that is protected against transparency to this degree. There's very little the state does where there is no right of any agency, no right of any legislative oversight whatsoever. So in an area where I think there should be more transparency, this bill would provide less transparency than we have in any other area in which the state takes action. So that concerns me. So I hope we can hold it in committee and at least clarify if the objective is to say the method by which they develop procedures, that's one thing, but that's not what this bill says.
Okay, thank you. Representative Mathias.
Thank you, Madam Chair. I'm going to support the substitute motion. I think we do need to codify the exemption from judicial review because it's becoming pretty annoying to the courts, and I think it's really important to do. But I do agree that the language, and I apologize, I should have caught this earlier. I did call some people, and I should have caught this earlier. But the word procedures lacks sufficient context. The only time it shows up in the text of the statute is the line above, and that's in reference to the director being able to determine that procedure, but it doesn't say procedure as to the use of a particular method. It just says procedure, and if it's the process that goes into the development of the procedure, I think we could be a lot more clear on that, because the implications of not being clear are, to what my colleague just referenced, pretty significant, and I think unintended.
Okay, Representative Ehart was next.
Thank you, Madam Chairman. I think I'm more comfortable with what's being proposed than not. I understand, though, Representative Rebel's concern. So rather than just holding it, which could be indefinitely, I'm going to make an amended substitute motion, and I move that we would hold House Bill, is it 525? 525 until or no later than February 11th. That gives us and the chairman a week if we needed to bring someone in to explain something. If before that time another change was recommended, then there's still plenty of time to bring it back. Because I understand the concern. So rather than holding it indefinitely, I'd like a time certain.
Okay, so we have an amended substitute motion to hold House Bill 525 in committee till no later than February 11th. Representative Gannon.
Thank you, Madam Chairman. And yeah, I was going to just make a motion to, but it's too late because there are three, to just send it to general orders, and I would support. I would support that. Just saying the development of such procedures shall be subject to. I mean, if that's what everybody intends, which it sounds like, then just say it. Just say the development of such procedures. But since there's already three, I'm going to support the last motion.
Okay.
Madam Chairman.
Representative Ehart.
Madam Chairman, I think that it would actually be beneficial to the committee if we were to get input from the sponsor as to what he thought might be the best path forward, because I am happy to withdraw my motion.
Okay. Representative Skog, could you come back up to the podium and give us some insight?
Thank you, Madam Chairman. I appreciate every question that each of you have asked, and I like your motion, Representative Ehart, but what Representative Gannon has shared, I think, would be the fix that we would come to. I think that's a great idea.
Okay, then, Madam Chairman, I would move for unanimous support to withdraw my motion.
Okay, we have an ask for unanimous support to remove the motion. That wasn't said, that's perfect. Unanimous consent. Is there anyone opposed? Is her pulling her motion? Okay, that's unanimous. And so now we're open for Representative Gannon, who may have a motion.
Thank you, Madam Chair. And I would move to send House Bill 525 to general orders. Of course, we can't attach an amendment or anything, but the intent would be just to clarify the particular line and use the term development.
Okay, we have a motion. Is there any more discussion? We have a motion to send House Bill 525 to general orders. We'll let Representative Skog take his seat. All in favor, say aye. Aye. Any opposed? The motion carries. That's all we have for today, so we're adjourned.